5.1 Introduction. Chapters 2, 3, and 4 focused on the scope of federal powers. This chapter examines limits on state authority. State and local governments possess the police power, which means that they can take any action unless there is a constitutional prohibition. State authority, of course, is different from that of the federal government, which can act only if there is constitutional authority. 1. State and local governments are limited by the Constitution's protections of individual rights, which are discussed in the remaining chapters. Also, the Constitution explicitly identifies a few instances where states may not act. Article I-10 states, "No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, or grant any title of nobility to." Preemption. This chapter focuses on limits on state power that derive from the existence of a national government and of other states. 3 There are two possibilities when considering whether a state or local law is invalidated because of these restrictions. One situation is where Congress has acted. If Congress has passed a law and it is a lawful exercise of congressional power, the question is whether the federal law preempts state or local law. Article 6 of the Constitution provides that the Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land. Because of the Supremacy Clause, if there is a conflict between federal law and state or local law, the latter is deemed preempted. 4 Preemption is discussed in 5.2. Dormant Commerce Clause. The other situation is where Congress has not acted, or at least the judiciary decides that federal law does not preempt state or local law. Nonetheless, even though there is not preemption, state and local laws can be challenged under two principles, the Dormant Commerce Clause and the Privileges and Immunities Clause. The Dormant Commerce Clause, or, as it is sometimes called, the Negative Commerce Clause, is the principle that state and local laws are unconstitutional if they place an undue burden on interstate commerce. The Supreme Court has inferred this limit on state regulatory power from the grant of power to Congress to regulate commerce among the states. Even if Congress has not acted, even if its commerce power lies dormant, state and local governments cannot place an undue burden on interstate commerce. Section 5.3 considers the Dormant Commerce Clause. Section 5.4 considers the application of this principle in a specific and important context, state and local taxation. Privileges and Immunities Clause. Another basis for attacking state and local laws in the absence of preemption is the Privileges and Immunities Clause of Article 4.2. This provision states, "The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states." As described in 5.5, the Supreme Court has interpreted the Privileges and Immunities Clause as limiting the ability of states to discriminate against out-of-staters with regard to constitutional rights or important economic activities. This clause primarily has been applied by the Supreme Court when there have been challenges to state and local laws that discriminate against out-of-staters with regard to their ability to earn a livelihood. Underlying policy themes. A central issue throughout this chapter is the appropriate degree of judicial oversight or of judicial deference to state and local governments. At one extreme, it is possible to argue that state and local governments should be unfettered by the federal government as much as possible. From this view, preemption should be restricted to those situations where Congress has expressly preempted state and local laws. Also from this view, there should not be a dormant commerce clause or only a very narrow one. State and local regulation generally should be limited only if Congress clearly precludes state and local actions. At the other extreme, some argue that it is essential for the judiciary to preserve the federal nature of American government. From this perspective, preemption is not something to avoid, but rather preemption should be found whenever doing so will better effectuate the interests of federal law and of the federal government. Likewise, the Dormant Commerce Clause is an essential restriction on abuses by state governments so as to preserve a free flow of goods and services throughout the economy. Thus, the material in this chapter is very much about federalism. What is the appropriate and desirable allocation of power between the federal government and the states and also among the state governments? What is the proper role of the judiciary in reviewing state and local regulations? 5.2 Preemption of state and local laws. 5.2.1 Introduction. As described above, Article 6 of the Constitution contains the Supremacy Clause, which provides that the Constitution, and laws and treaties made pursuant to it, are the supreme law of the land. If there is a conflict between federal and state law, the federal law controls and the state law is invalidated because federal law is supreme. 1 As the Supreme Court declared, under the Supremacy Clause, from which our preemption doctrine is derived, any state law, however clearly within a state's acknowledged power, which interferes with or is contrary to federal law, must yield to. The difficulty, of course, is in deciding whether a particular state or local law is preempted by a specific federal statute or regulation. 3 As in so many other areas of constitutional law, there is no clear rule for deciding whether a state or local law should be invalidated on preemption grounds. The Supreme Court once remarked that there is not an infallible constitutional test or an exclusive constitutional yardstick. In the final analysis, there can be no one crystal clear distinctly marked formula. 4. Ways of finding preemption. Traditionally, the Supreme Court has identified two major situations where preemption occurs. One is where a federal law expressly preempts state or local law. The other situation is where preemption is implied by a clear congressional intent to preempt state or local law. In Gade v. National Solid Wastes Management Association, the court summarized the tests for preemption. Preemption may be either express or implied, and is compelled whether Congress' command is explicitly stated in the statute's language or implicitly contained in its structure and purpose. Absent explicit preemptive language, we have recognized at least two types of implied preemption: field preemption, where the scheme of federal regulation is so pervasive as to make reasonable the inference that Congress left no room for the states to supplement it, and conflict preemption, where compliance with both federal and state regulations is a physical impossibility, or where state law stands as an obstacle to the accomplishment and execution of the full purposes and objectives of Congress. 5. Problems with applying the test for preemption. Although these categories, or minor variations, are frequently used, they are not distinct. For example, even if there is statutory language expressly preempting state law, Congress rarely is clear about the scope of what is preempted or how particular situations should be handled. Courts must decide what is preempted, and this inevitably is an inquiry into congressional intent. 6 Conversely, implied preemption is often a function of both perceived congressional intent and the language used in the statute or regulation. The Supreme Court has recognized that in both express and implied preemption, the key is discerning congressional intent. The court has said that the question of whether a certain state action is preempted by federal law is one of congressional intent. 7 It has remarked that the purpose of Congress is the ultimate touchstone in every preemption case. 8 The problem, of course, is that Congress's intent, especially as to the scope of preemption, is rarely expressed or clear. Therefore, although the court purports to be finding congressional intent, it often is left to make guesses about purpose based on fragments of statutory language, random statements in the legislative history, and the degree of detail of the federal regulation. The court frequently has said that congressional intent must be clear to find preemption because of a desire, stemming from federalism concerns, to minimize invalidation of state and local laws. Thus, the court has observed, Congress should manifest its intention to preempt state and local laws, clearly. The exercise of federal supremacy is not likely to be presumed. 9 Similarly, the court declared, because the states are independent sovereigns in our federal system, we have long presumed that Congress does not cavalierly preempt state law causes of action. In all preemption cases, and particularly in those in which Congress has legislated in a field which the states have traditionally occupied, we start with the assumption that the historic police powers of the states were not to be superseded by the federal act unless that was the clear and manifest purpose of Congress. 10. 3 situations where preemption claims arise. For the sake of clarity, this section is organized parallel to the test for preemption articulated by the Supreme Court in Gade v. National Solid Wastes Management Association that is quoted above and that has been frequently repeated by the court. 11 There are 3 major situations where preemption is found. First, express preemption occurs where there is explicit preemptive language. This type of preemption is discussed in 5.2.2. Second, there is implied preemption. The court has identified 3 types of implied preemption. One is termed field preemption, where the scheme of federal law and regulation is so pervasive as to make reasonable the inference that Congress left no room for the states to supplement it. 12. Field preemption is discussed in 5.2.3. Another type of implied preemption occurs when there is a conflict between federal and state law. Even if federal law does not expressly preempt state law, preemption will be found where compliance with both federal and state regulations is a physical impossibility. 13. Preemption based on such conflicts is discussed in 5.2.4. Implied preemption also will be found if state law impedes the achievement of a federal objective. Even if federal and state laws are not mutually exclusive, and even if there is no congressional expression of a desire to preempt state law, preemption will be found if state law stands as an obstacle to the accomplishment and execution of the full purposes and objectives of Congress. 14. Preemption based on state law interfering with the achievement of a federal objective is discussed in 5.2.5.15. Although these types of preemption are presented as distinct categories, in practice they often overlap and they certainly are not mutually exclusive. As is discussed below, all of these categories frequently turn on a determination of congressional intent. The common problem is that Congress's intent concerning preemption frequently is unclear. 16. Congress often is silent on the preemption question. Even when Congress expresses a desire for preemption, it rarely indicates the scope of preemption or provides guidance for the myriad of situations that will arise. Perhaps it is for this reason that there has been a dramatic increase in preemption decisions by the United States Supreme Court. 17. Preemption issues arise in literally every area of federal law and federal regulation. Finally, there is a third major situation where preemption might be found. States generally cannot tax or regulate federal government activities. Although this can be viewed as a form of preemption because state laws are invalidated based on the Supremacy Clause, this type of preemption is different from the others because it does not depend on congressional intent. This type of preemption is discussed in 5.2.6. The underlying policy issues. Ultimately, preemption doctrines are about allocating governing authority between the federal and state governments. A broad view of preemption leaves less room for governance by state and local governments. It is for this reason that, at times, the court has declared that the preemption analysis starts with the assumption that the historic powers of the states are not to be superseded by federal act unless that is the clear and manifest purpose of Congress. 18. But a very narrow preemption doctrine minimizes the reach of federal law and risks undermining the federal objectives. Therefore, it is somewhat surprising that the Rehnquist and the Roberts courts, with their commitment to federalism and protecting states' rights, have been quite willing to find federal preemption. 19. One way to empower states is to narrow the reach of federal preemption, but this has not occurred. The basic question is how willing courts should be to find preemption. Should there be a strong presumption against a court concluding that there is preemption? If so, what should be sufficient to overcome this preemption? Or should courts be willing to find preemption whenever doing so would effectuate the purposes of federal law? 5.2.2 Express preemption of state laws. Federal laws can explicitly preclude state regulations. Whenever Congress has the authority to legislate, Congress can make federal law exclusive in a field. The clearest way for Congress to do this is to expressly preclude state or local regulation in an area. Thus, some federal laws contain clauses that expressly preempt state and local laws. For example, the Federal Employee Retirement Income Security Act of 1974, ERISA, states that it supersedes any and all state laws insofar as they may now or hereafter relate to any employee benefit plan. 20. Jones v. Rath Packing Company is a case involving this type of preemption. 21. The Federal Meat Inspection Act stated, marking, labeling, packaging, or ingredient requirements in addition to, or different than, those made under this act may not be imposed by any state. 22. The federal law and a state law both required that every package of bacon contain an amount at least equal to that stated on the package. They differed, however, in that the federal law permitted deviations because of moisture loss, while the state law did not permit variations from the stated amount on that basis. The court found that the express language of the statute dictated the preemption of the state law. Another example of a statute containing express preemptive language is the Airline Deregulation Act of 1978, which provides, no state shall enact or enforce any law, rule, regulation, standard, or other provision having the force and effect of law relating to rates, routes, or services of any air carrier. 23. In Morales v. Trans World Airlines, Inc. The court applied this provision to find that price advertising guidelines promulgated by the National Association of Attorneys General could not be applied to airlines because they related to rates. 24. The court broadly interpreted the language of the Act as expressly preempting all state laws having a connection with or reference to airline rates, routes, or services. 25. The court said that Congress's purpose was to ensure that the states would not undo federal deregulation with regulation of their own. 26. Similarly, in American Airlines, Inc. v. Wallens, the court held that the Airline Deregulation Act preempted an action under a state consumer fraud law against an airline for deceptive practices concerning its frequent flyer program. 27. The court explained that the matter concerned the services of an air carrier, and thus the application of the state law was preempted by federal law. However, the court found that the Act did not preempt a state law claim for breach of contract because the action was based on the airline's own promises and not duties imposed by the state government. The scope of preemption is rarely clear. The problem is that even when an express preemption clause exists, it rarely provides guidance as to the scope of preemption. The Supreme Court's decision in Regal v. Medtronic, Inc. is illustrative. 28. The Federal Medical Devices Act preempts states from imposing requirements greater than federal law for medical devices approved by the federal government. 29. The case involved a man who was seriously injured when a balloon catheter exploded during angioplasty surgery. He sued the manufacturer, and the issue was whether the preemption of greater state requirements precluded state tort liability. In an 8-1 decision, the court found preemption. Justice Scalia, writing for the court, explained that liability under state common law, like state regulation, could impose additional duties on manufacturers of medical devices. He declared that, absent other indication, reference to a state's requirements includes its common law duties. 30. Justice Ginsburg, in a dissenting opinion, said that if Congress wanted to preclude state tort liability it could have done so, and that requirements should not be interpreted as preempting common law claims. She lamented that there was no indication from the legislative history of a desire to preempt tort claims, and that it is difficult to believe that Congress would, without comment, remove all means of judicial recourse for consumers injured by FDA-approved devices. 31. Thus, even though there was an express preemption provision, there still was the need to interpret it and decide what constitutes forbidden state requirements. 2 cases concerning the ability of states to regulate cigarettes also show the need for judicial interpretation of express preemption provisions. Cipollone v. Liggett Group, Inc., which involved the ability of states to allow liability against tobacco companies, illustrates the inability to decide preemption issues solely based on a textual provision. 32. A lawsuit was brought against cigarette manufacturers by a victim of lung cancer and her husband. The suit alleged that the companies had breached express warranties contained in their advertising, because they had failed to warn consumers about the hazards of smoking, because they had fraudulently misrepresented those hazards to consumers, and because they had conspired to deprive the public of medical information about smoking. The Federal Cigarette Labeling and Advertising Act required that there be a warning of smoking's health hazards on all packages of cigarettes sold. A section of a law adopted in 1965, captioned preemption, provided no statement relating to smoking and health, other than the federally prescribed warning, shall be required on any cigarette package, and no such statement shall be required in the advertising of any cigarettes. A 1969 law provided, no requirement or prohibition based on smoking and health shall be imposed under state law with respect to the advertising or promotion of any cigarettes the packages of which are labeled 33. The issue in Cipollone was whether these provisions preempted a state from awarding damages on claims for torts such as failure to warn and fraudulent misrepresentation. The court held that the 1965 provision did not preempt state damage actions but, rather, only state laws and regulations mandating specific warnings on cigarette labels or in cigarette advertising. The court emphasized that there is no general, inherent conflict between federal preemption of state warning requirements and the continued vitality of state common law damages actions. 34. The court, however, ruled that the broader language in the 1969 Act did preempt state damage actions for failure to warn and fraudulent misrepresentation. 35. The plurality opinion said that it had long recognized the phrase state law to include common law as well as statutes and regulations. 36. Specifically, the court concluded that failure to warn suits were preempted insofar as they claimed that advertisements should have included additional, or more clearly stated, warnings. 37. but the court ruled that the claim for breach of express warranties was not preempted. The plurality opinion said that the warranties were created by the cigarette companies and not the federal or state law. Therefore, even if the warranties were stated in the federally required warnings, this did not prevent suits against the companies for breaching those warranties. As to the fraudulent misrepresentation claims, the court ruled that federal law preempted the state from allowing liability for advertising that allegedly undermined the effect of the federally mandated warning labels. However, the court said that federal law did not preempt fraudulent misrepresentation claims based on intentional concealment of information through channels other than advertising. Also, claims of conspiracy to misrepresent or to conceal material facts were deemed to be not preempted. Sipoln powerfully illustrates that express preemption provisions require judicial interpretation as to what specific types of state law are preempted. This issue also is present in a second, subsequent case concerning state regulation of tobacco advertising. In Lorillard Tobacco Company v. Riley 38, the court invalidated a Massachusetts law that prohibited outdoor advertising for cigarettes, such as billboards, within 1,000 feet of a playground or school. 39 The Supreme Court relied on the language of a federal law adopted in 1969 that prescribes any requirement or prohibition based on smoking and health, imposed under state law with respect to the advertising or promotion of cigarettes. 40 The court reviewed the history of federal regulation of cigarette advertising and concluded, in the 1969 amendments, Congress not only enhanced its scheme to warn the public about the hazards of cigarette smoking, but also sought to protect the public, including youth, from being inundated with images of cigarette smoking in advertising. In pursuit of the latter goal, Congress banned electronic media advertising of cigarettes. And to the extent that Congress contemplated additional targeted regulation of cigarette advertising, it vested that authority in the FTC. 41. Justice Stevens, in a dissenting opinion, argued that the state law was not preempted because it regulated the location and not the content of cigarette advertisements. 42 The majority, however, rejected this distinction and declared, but the content/location distinction cannot be squared with the language of the preemption provision, which reaches all requirements and prohibitions imposed under state law. A distinction between the content of advertising and the location of advertising in the FCLA also cannot be reconciled with Congress' own location-based restriction, which bans advertising in electronic media, but not elsewhere. 43 The majority said that general zoning regulations limiting outdoor advertisements could be applied to cigarettes, but not laws targeting just tobacco products. The court also faced this issue concerning the scope of an express preemption provision in Bates v. Dow AgroSciences LLC. 44 Peanut farmers sued a pesticide manufacturer claiming that the use of a particular pesticide caused severe crop damage. The manufacturer argued that there was preemption based on the Federal Insecticide, Fungicide, and Rodenticide Act, FIFRA. 45 The specific provision that allegedly preempted state law provided, such states shall not impose or continue in effect any requirements for labeling or packaging in addition to or different from those required under this subchapter. 46 The court expressly distinguished Sipoln and said that unlike the statute there, FIFRA prohibits only state law labeling and packaging requirements that are in addition to or different from the labeling and packaging requirements under FIFRA. 47 A state law would not be preempted if it was consistent with the requirements of FIFRA. The court thus narrowly construed the express preemption clause as not precluding the suit by the Texas peanut farmers. The court stressed that this was an area of traditional state control and thus the preemption clause was to be read narrowly. The court stated, the long history of tort litigation against manufacturers of poisonous substances adds force to the basic presumption against preemption. If Congress had intended to deprive injured parties of a long available form of compensation, it surely would have expressed that intent more clearly. 48. Another example of the difficulty of construing the scope of express preemption provisions is Chamber of Commerce v. Whiting. 49 Federal immigration law expressly preempts any state or local law imposing civil or criminal sanctions, other than through licensing and similar laws, upon those who employ unauthorized aliens. 50 An Arizona statute, the Legal Arizona Workers Act, provided that the licenses of state employers that knowingly or intentionally employ unauthorized aliens may be, and in certain circumstances must be, suspended or revoked. 51 The Supreme Court focused on the language in the federal law that has an exemption for licensing and similar laws. The court found that Arizona's law, which would revoke business licenses for those who employ undocumented immigrants, falls within this exception. The court declared, "We hold that Arizona's licensing law falls well within the confines of the authority Congress chose to leave to the states and therefore is not expressly preempted." 52. But the dissenting justices disagreed over the meaning of the word licensing. Justice Breyer, joined by Justice Ginsburg, wrote, "Arizona calls its state statute a licensing law and the statute uses the word licensing. But the statute strays beyond the bounds of the federal licensing exception, for it defines license to include articles of incorporation and partnership certificates. Indeed, virtually every state law authorization for any firm, corporation, or partnership to do business in the state. Congress did not intend its licensing language to create so broad an exemption, for doing so would permit states to eviscerate the Federal Act's preemption provision, indeed to subvert the Act itself, by undermining Congress efforts, 1. to protect lawful workers from national origin-based discrimination and, 2. to protect lawful employers against erroneous prosecution or punishment." 53. The key point is that provisions in federal statutes expressly preempting state and local laws inevitably require interpretation as to their scope and effect, as illustrated by the disagreement among the justices in Chamber of Commerce v. Whiting as to the meaning of the word licensing. The explosion of litigation concerning the preemption provision in the Employee Retirement Income Security Act of 1974, ERISA, also demonstrates this. ERISA broadly preempts state laws that relate to employee benefit plans. 54. A key problem, though, is the inherent ambiguity in the phrase relates to. As Professor Fisk observed, relates to is a term that requires a modifier in order to have a concrete meaning, and the spectrum of possible modifiers, directly, slightly, remotely, suggests a wide spectrum of possible meanings. 55. Employers and others have argued that many state laws, from family leave to workers' compensation to health care finance and malpractice claims, are preempted by ERISA because they relate to employee benefit plans. 56. In the decades since ERISA was enacted, the court has rendered decisions with written opinions in dozens of ERISA preemption cases and also decided many others without a written opinion. 57. In 1992, Justice Stevens said that overall in the country there had been 2,800 judicial opinions on ERISA preemption. 58. And a 1995 study found 3,153 cases. 20 years later, the number undoubtedly is vastly larger. The sheer quantity of ERISA litigation shows that an express preemption provision leaves open countless questions about the scope of that preemption. 59. All of these cases indicate that even when there is an express preemption provision, a court inevitably must decide the domain expressly preempted by that language. This leaves the court tremendous discretion and often leads to seemingly arbitrary and inconsistent answers. 5.2.3 Field preemption. Field preemption defined. Even if there is not express preemption, the Supreme Court has ruled that it will find implied preemption if there is a clear congressional intent that federal law should exclusively occupy a field. The court has said that such preemption exists if either the nature of the regulated subject matter permits no other conclusion, or that the Congress has unmistakably so ordained. 60. In other words, the court will find field preemption either if Congress expresses a clear intent that federal law will be exclusive in an area, or if comprehensive federal regulation evidences a congressional desire that federal law should completely occupy the field. The court has said that, absent explicit preemptive language, Congress's intent to supersede state law altogether may be found from a scheme of federal regulation so pervasive as to make reasonable the inference that Congress left no room for the states to supplement it. 61. The difficulty is in deciding when congressional intent is sufficiently specific or federal regulation sufficiently detailed so as to preclude all state regulation in a field. Again, as expressed above, there are no clear criteria for courts to decide this, and inevitably courts must make a judgment call based on whether the interests behind the federal law will be best served by the law being exclusive in a field. The court's decision in Chamber of Commerce v. Brown is illustrative of this problem. 62 California law prohibits employers that receive state grants or more than $10,000 in state program funds per year from using the funds to assist, promote, or deter union organizing. 63 Although the court acknowledged that the National Labor Relations Act contains no express preemption provision, the court said that it reflects a policy choice that both employers and employees be allowed to speak with regard to the issue of union organizing and that this be left largely to market forces. The court concluded that the California law interfered with this by imposing a restriction on employer speech. But, as Justice Breyer argued in dissent, all California did was to prevent employers from using state funds to discourage union organizing. 64 He explained, he law normally gives legislatures broad authority to decide how to spend the people's money. A legislature, after all, generally has the right not to fund activities that it would prefer not to fund, even where the activities are otherwise protected. 65 Thus, the disagreement between the majority and the dissent was over the scope of field preemption under a federal statute that is silent about preemption. Foreign policy and immigration as an example. One place where the court often has found field preemption is in the area of foreign policy and immigration. 66 The federal government has exclusive authority in dealing with foreign nations, and therefore state regulations in this area are preempted. The problem, though, is deciding how far this preemption extends in invalidating state and local laws that have an indirect effect on foreign policy or immigration. Hines v. Davidowitz is a classic example of preemption of state regulation in the field of immigration. 67 A Pennsylvania law required aliens to register with the state, carry a state-issued registration card, and pay a small registration fee. The Supreme Court deemed this law preempted by emphasizing that alien registration is in a field which affects international relations, the one aspect of our government that from the first has been most generally conceded imperatively to demand broad national authority. 68. The court stressed the extensive federal regulation in the area, including a broad and comprehensive plan describing the terms and conditions upon which aliens may enter this country, how they may acquire citizenship, and the manner in which they may be deported. 69 Indeed, a federal law specifically required alien registration with the federal government. Two aspects of Hines are particularly noteworthy. First, the court found preemption of a state law that complemented the federal law. The state law in no way interfered with the federal law or its implementation. 70 Field preemption means that federal law is exclusive in the area and preempts state laws even if they serve the same purposes as the federal law and do not impede the implementation of federal law. Second, the court found field preemption in Hines even in the absence of express preemptive language in the federal statute. Congress certainly could have explicitly preempted state alien registration in the federal law that required aliens to register. But Congress did not do this. The dissent in Hines emphasized this point. At a time when the exercise of the federal power is being rapidly expanded through congressional action, it is difficult to overstate the importance of safeguarding against such diminution of state power by vague inferences as to what Congress might have intended if it had considered the matter or by reference to our own conceptions of a policy which Congress has not expressed and which is not plainly to be inferred from the legislation which it has enacted. The judiciary of the United States should not assume to strike down a state law which is immediately concerned with the social order and safety of its people unless the statute plainly and palpably violates some right granted or secured to the national government by the Constitution or similarly encroaches upon the exercise of some authority delegated to the United States for the attainment of objects of national concern. 71. The dispute between the majority and the dissent in Hines, over whether preemption should be found in the absence of an explicit congressional declaration, continues to this day. As described above, ultimately it is a tension between the desire to effectuate the interests of the federal government and the desire to limit the instances where state power is limited. Later cases have followed Hines and have found that state laws concerning immigration are preempted. In Takahashi v. Fish and Game Commission, the court declared preempted a state law that precluded aliens who were not eligible for citizenship under federal law from obtaining commercial fishing licenses. 72 The court used expansive language to find the state law preempted. The federal government has broad constitutional powers in determining what aliens shall be admitted to the United States, the period they may remain, regulation of their conduct before naturalization, and the terms and conditions of their naturalization. Under the Constitution the states are granted no such powers. State laws which impose discriminatory burdens upon the entrance or residence of aliens lawfully within the United States conflict with this constitutionally derived federal power to regulate immigration. 73. Similarly, in Toll v. Moreno, the court found a state law preempted that denied in-state tuition to non-immigrant aliens that it accorded to citizens and to immigrant aliens. 74 A non-immigrant alien, for example, was a child of officers or employees of international organizations who were in the United States because of their work. the court found preemption based on the broad principle that state regulation not congressionally sanctioned that discriminates against aliens lawfully admitted to the country is impermissible if it imposes additional burdens not contemplated by Congress. 75. In contrast, in Ducanas v. Baker, the court found that there was not preemption of a state law that precluded employment of undocumented aliens if that employment would adversely affect resident workers. 76. The court noted that the power to regulate immigration is unquestionably exclusively a federal power. 77. Nonetheless, the court concluded that there was not preemption because Congress intended that the states be allowed, to the extent consistent with federal law, to regulate the employment of illegal aliens. 78. The most recent, and likely the most important, Supreme Court decision concerning preemption in the area of immigration law is Arizona v. United States. 79. In 2010, Arizona adopted a law, SB 1070, which among other things requires officers to check a person's immigration status if there is reasonable suspicion that the person is in the United States illegally, and authorizes officers to make a warrantless arrest of a person where there is probable cause to believe that the person committed a public offense that makes the person removable from the United States. 6. SB 1070 also requires that non-citizens carry registration papers showing they are lawfully in the United States. 3. And makes it a crime for those who are not lawfully present to apply for or be hired for work. 5. 80. Arizona's SB 1070 declares its purpose to be decreasing the presence in the state of undocumented immigrants through aggressive law enforcement and attrition.